One of the most important rules in competition law is ensuring that prices at any level of trade are always set up independently. That concerns both competitors, which should set their prices independent of each other, but also within a distribution chain looking down. So from a manufacturer to a distributor, and from a distributor to a reseller, each link to the chain should have their own rights to decide on the prices. One of the judgments and rules that further elaborated on this was the Spanish Glaxo case, ruled in 2010s, which clearly stated that you cannot apply in a relation between a supplier and a distributor, a supplier and a wholesaler, you cannot apply different prices with regards to which channel this supplier or wholesaler will resell those products to. Now this is subject to a change.
So the context of the legal situation we are discussing today dates back to 2010, when the previous VBER and the guidelines had been adopted. So at that time, e-commerce was, although present, it was significantly smaller as compared to its today's size. So at that time, the EU legislator assumed that it was precisely the online trade which deserved some form of legal support. For example, a ban on dual pricing was established. Nowadays, it is rather the traditional brick-and-mortar trade which faces significant competition from the online retailers. So the EU legislator came to a conclusion that the set of preferential treatment for e-commerce is no longer necessary. So under the new regime, dual pricing will be allowed.
The new vertical block exemption regulation, which has come into force on the 1st of June 2022, has changed this very rule regarding dual pricing. The new regulation clearly states that a distributor, a wholesaler, or any other entity within the distribution chain is allowed to differentiate sale prices to their, for example, retailers, and differentiates this price depending on which channel the retailer is going to sell this product to. For example, a reseller who purchases products and sells them both in the brick-and-mortar stores and on the internet will have, for example, two different price lists, one for brick-and-mortars, one for internet sales. This change is rather significant as it changes the paradigm and the approach that was prevalent in competition law in the last 15 years. This, however, doesn't come without any practical problems.
So obviously we don't know yet what real challenges and problems will the companies face, but we may probably at this moment foresee at least some of them. So it is worth considering, for example, how a distributor who is operating a distribution network and benefited from the current permission to use dual pricing, how such distributor would be able to verify which products were ultimately sold through online and which were sold through offline channels. This of course applies to a situation in which a particular entity operates both traditional stores and has an online store. So such distributor should be able to verify which products were sold through different channels of trade in order to settle the account between his business partners. Another interesting situation may also arise when consumers order or even purchase products online, but they decide to pick up the goods in the traditional store. So we should be able to verify if such transaction amounts to online or offline transactions. So those are just a few examples of potential problems or challenges that the companies will have to deal with in the near future.
This change, however, is not unilateral. It doesn't apply uniformly to every single distribution channel and every single situation in the distribution chain. We have to remember that this vertical block exemption regulation applies only to certain distribution agreements where the parties meet market shareholder thresholds. Furthermore, the allowing of dual pricing with regards to brick and mortar and internet stores doesn't mean that you can set up dual pricing mechanisms which, for example, differentiate between sales locally and exporting practices. This is a very important regulation, a very important distinction to be kept in mind, as the vertical block exemption is, as the name suggests, just an exemption, and general competition rules and principles still apply. There's still more to come with regards to how to interpret and how to apply the new vertical block exemption regulations. So please make sure to follow our LinkedIn and YouTube accounts for more information in our cycle of educational videos. Thank you very much.
Thank you.